So good morning, everyone, or good afternoon, depending on where you are joining us from. Thank you for joining us for today's event on protecting the press, international standards, and judicial trends in cases of violence against journalists. We look forward to this important discussion on this critical challenge that is affecting journalists around the world. It's no secret that violence against journalists and human rights defenders has been on the rise in the last decade. Journalists have been persecuted, spied on, stigmatized, and incarcerated in record numbers. And authoritarian governments, more recently around the globe, used the COVID-19 pandemic as an excuse to harass independent media. So social unrest has often put journalists at risk, and new forms of violence, such as bulk or targeted surveillance and online harassment, especially on women journalists, has contributed to a blink present regarding the conditions that are necessary for the activities of journalists and human rights defenders to thrive. With this in mind, the Global Freedom of Expression Initiative worked over the last year to expand its case law database with the most relevant cases related to violence against journalists. Our researchers, extraordinarily led by the moderator and presenter for today's event, Dr. Ramiro Álvarez Ugarte, sought to capture and highlight global judicial trends, analyze new judicial decisions, and showcase those cases that held states accountable and upheld international human rights standards. As part of this project, we hosted a series of workshops to train lawyers, journalists, and activists on regional jurisprudence, international human rights standards, and best practices. With each one of those workshops, featuring key regional experts, these trainings focus on jurisprudence in Asia, Africa, MENA, and Europe, and the Inter-American system, as well as on universal human rights standards. You can find all of these videos on our program's webpage and our YouTube channel. To wrap up our work on this project, we are hosting this capstone event to present our findings and hear from our experts on what else can be done to tackle this monumental challenge. After the event, we also invite you to explore our case law database to learn about many of the emblematic cases and judicial trends we will be discussing today. And finally, I am honored to present and welcome our two featured speakers for today's event. Barbara Bukowska from Article 19 and Rachel Kay from IFEX. Two worldwide champions on freedom of expression. Barbara has done incredible work on the most important theoretical issues related to freedom of expression, and she has greatly contributed to the creation and promotion of the international standards related to these human rights. And Rachel has been fundamental in building and promoting an amazing international network between journalists, civil society organizations, and lawyers, and other key actors dedicated to the defense of freedom of expression worldwide. Both of these speakers have played significant direct roles in the advancements of international standards and good practices related to free expression and information. And we owe them tremendously for their commitment and contributions to this field. We sincerely thank you both for your time today, and we are greatly looking forward to hearing your insights and commentary. And with that, I will turn the floor over to Ramiro. Thank you.
Thank you very much, Catalina, and thanks, Barbara and Rachel, for joining us today. I'm going to very briefly present some of the findings of this research project within the Global Freedom of Expression project at Columbia University. I was lucky to receive the insights and findings of 6 senior researchers who basically worked around the world in different regions in Latin America, North America, Europe, Africa, MENA, and Asia, trying to find what are the current trends in terms of violence against journalists. Not so much in terms of describing the problem, but in terms of how the judiciary is acting regarding the problem, under the premise that international human rights standards have a role to play in especially in the prosecution and punishment of violence against journalists, under the idea as well that impunity is a facilitator of violence. So this project basically sought to expand the database of the Global Freedom of Expression project of cases, and in order to get a better look at what the judiciary is doing around the world. So I will tell you very briefly what those researchers found. I was able to look at the decisions and the summaries they produced. And basically, they identified lots of cases, of course. Of those cases, we settled down on 75 of them, and we had a lot of difficulties in accessing court documents in many countries and in many regions. And we were able to analyze and study and summarize 43 new decisions. Now, our sort of premise was to look at international standards and to look at how national courts used international standards in order to address the violence against journalists. Of course, when you're looking at courts, you're looking at a later stage of the problem. You're looking at moments where violence has already occurred. On some cases, you're looking at judges intervening as parts of mechanisms of protection. But generally, you're dealing with cases in which violence has already occurred. That is one part of the international standards, especially. It has to do with the duty to prosecute and punish violence against journalists because impunity fosters violence. Now, international standards that we also analyze and introduce have also to do with the duty to prevent violence in context of structural violence and to protect journalists who are under specific or general risks. I mean, who are at risk personally because of who they are, because of the bits they cover, because of the territory in which they develop their work, or who are generally at risk because they are working within an environment of structural violence. These standards have been mainly created by 2 regional international human rights systems. It's basically the European Court of Human Rights and the Inter-American System of Human Rights, including both the Inter-American Commission and the Inter-American Court. And what we saw when we tried to systematize these standards is that both of them seem to be the most important sites of norm creation around the world in terms of what these international standards are. We also found that UN soft law especially is very important, but we did not find a lot of cases in the UN case system in front of the Human Rights Council that deal with the issue of violence. We looked at that, but we didn't find that many cases. It seems that that system has not been particularly used to develop interpretations on freedom of expression in relation to violence against journalists. And what we found there is that basically the European Court of Human Rights has the most amount of cases, and some of the standards do come straight of those cases. But the Inter-American Court of Human Rights has also a bunch of cases in which they also did some doctrinal developments. And the Inter-American Commission, especially through the Office of the Special Rapporteur of Freedom of Expression, has been probably the office that best systematized these standards. And that possibly has a link with the fact that these standards have a place in the Latin American countries that have used these standards in order to adjudicate cases of violence against journalists. Now, what did we find? The main insight and finding has to do with a lot of variation across regions in terms of what judges do regarding these cases. In Latin America and Europe, you find these standards at play. You find national judges basically using these standards to decide these cases. That is not the case on Asia, Africa, and MENA. In the cases we were able to analyze in all these regions, the international standards have no presence at all. And that, I think, poses a question and a challenge in terms of how to make those standards useful and known in those regions. In many of these countries, what we found in the last regions that I mentioned, what we found is basically that cases of violence against journalists are treated as cases of violence. So they're treated as common criminal issues. So for instance, an arson attack against a journalist in Lebanon is treated as an arson attack against a person, and it's discussed as a common criminal issue. And the freedom of expression dimension of the case is somewhat lost in the analysis. And this has, of course, consequences in terms of the role judges play in combating violence against journalists. That is not the case in other regions. So for instance, in Colombia, the Constitutional Court has not only embraced this international standard, but has also developed them within local constitutional law and has also expanded them. Now, in our research, we also, from the departing point, the idea was to look at violence, but also to look at new forms of violence. So traditional definitions of violence against journalists usually include murder, of course, direct acts of aggression, harassment, and threats. But we also wanted to include what we label new forms of violence. So for instance, we try to look at cases involving surveillance, and we try to look also at cases of harassment, especially online harassment against women journalists. And we didn't find a lot of cases dealing with this issue, and I think that has a methodological explanation. When you look at co-decisions, you're usually looking at facts that happened a few years ago, at least. But we did find a couple of good examples. So for instance, there is a very interesting case in the Netherlands that strikes, I think, the right balance between what constitutes legitimate critical engagement with journalists as public persons and what constitutes true forms of harassment based on discriminatory and sexist speech. So there are emerging trends that you can find there that are coming up and are really important. In the end of the day, and especially through the workshops in which we have been able to discuss the specificities of each region in the last few weeks, I think we've learned a couple of things. The first thing is that obviously the issue of violence against journalists will go well beyond judges. But at the same time, judges have a very important role to play in combating violence, specifically in terms of combating impunity. That is a fundamental lesson, we think. We hoped with this research and the expansion of the global database that these cases and that the international standards will sort of expand and move through the different regions of the world, but that also leaves something to do for the future. Certain work in terms of educating public officials, judges, prosecutors, academics in all these regions of the world in which international standards does not seem to have penetrated local legal cultures yet. Those are the main findings of this research. And without further ado, I will give the floor to Rachel. I think that's the order we agreed before, right? Rachel first and Barbara later. Great. Rachel, the floor is yours. Thank you very much.
Great. Thank you, Ramiro and Catalina and Colombia's Global Freedom of Expression program for inviting me to participate in this event. It's really such a pleasure to be amongst friends and colleagues today to share some thoughts on the report as well as insights on this ever-growing challenge. As IFEX is a global network of over 100 member organizations promoting and defending freedom of expression, I'd like to focus on two main areas. One is a reflection on the conditions that lead to increased attacks against journalists observed in this report, and really the importance of a healthy space for addressing these problems. Second, I'd like to share some insights on the value and challenges of leveraging international standards to reinforce advocacy for journalist safety on the ground, which many members of IFEX are engaged in. The report notes a number of structural issues that have magnified the threat to journalists. For example, weak or captured institutions and rampant crime rates create a general environment of instability, leaving journalists exposed and vulnerable. It also leaves little option for formal recourse when they're targeted. Legal frameworks that should provide a safe and enabling climate for the media are instead used to target journalists under the guise of countering terrorism, cybercrime, or disinformation. Periods of social unrest linked to economic or political grievances have also correlated with an increase in violence against journalists covering these events. And I think Barbara will speak a bit more to this in a little bit. These issues, we feel, can be mitigated by ensuring there's a healthy civic space where citizens, civil society organizations, and other diverse perspectives are able to be voiced without undue restrictions or fear of reprisal. Within this, it is also key that governments guarantee an enabling environment for freedom of expression, and that they and other stakeholders meaningfully collaborate with civil society organizations. This report also makes important observations about the positive obligations of the state. And you were just speaking about that previously, Ramiro. For this, it's crucial for governments to recur to accurate and reliable information about trends and threats to the safety of journalists. Many IFEX members do this monitoring and reporting. Governments should include their information as well as engage directly with these organizations when considering measures to prevent, protect, and prosecute crimes against journalists, and ensure they have the funding and resources to carry out this work. For example, in Pakistan, such documentation, as well as long-term advocacy carried out by IFEX member, the Pakistan Press Foundation, was essential in the development and passage of a landmark journalist protection bill in the country's National Assembly. Government engagement with civil society contributes to an improved understanding of the negative impacts of bad legislation, as well as to revising laws that don't adhere to international standards. IFEX members are working to ensure that their governments have the information they need to effect change. This can be seen through the multi-stakeholder process that Globe International Center in Mongolia has used to push for the decriminalization of defamation laws frequently used to target critical reporting, especially during the COVID-19 pandemic, by recurring to outcomes from the country's UPR and other global standards. Organizations working on media freedom can also be key to providing training and dialogue with law enforcement on respecting and protecting the right for journalists to report on protests or elections, further limiting instances of violence. This type of work is being carried out in Uganda by the Human Rights Network for Journalists, who initiated a platform to dialogue with security officials to encourage exchange and cooperation with governments and the media, building from the fraught experience of Uganda's elections in 2021. With regards to the case law included in this report, this centralized collection of relevant jurisprudence is crucial for connecting a patchwork of cases at the international and regional level that can be used to hold states accountable to their obligations through policymaking and the court system. The breakdown of case law in the report according to types of attacks and those that have specific gender dimensions is particularly useful. At IFEX, we've seen how access to these decisions can provide CSOs with legal backing to strengthen interventions in cases through strategic litigation. A particularly powerful example of this is through the work of Fundación para la Libertad de Prensa, SEGIL, IFEX, and others that intervened in the case of Ginat Bedoya, which ultimately led to many historic precedents mentioned in this report, both at the regional level, but also serving as a reference for other parts of the globe. More about this was shared by Jonathan from PLIP during Monday's event. Another example is the cases of Gambian journalists Ibrima Mane and Dada Haidera. Here, Rulings from the ECOWAS Court of Justice in West Africa, advocated for by member organizations Media Foundation for West Africa and the Gambia Press Union, later enabled them to successfully secure reparations and the inclusion of these cases in the country's Truth and Reconciliation Commission. Similarly, another IFEX member, Syrian Center for Freedom of Expression and the Media, are using international courts and jurisprudence to push for justice for victims of attacks against the press carried out during Syria's civil war, under the principle of universal jurisdiction. However, we've also seen the challenges posed by international and regional standards that are not accessible, preventing CSOs from incorporating these precedents into their work on the safety of journalists. Producing reports like this are key to strengthening this work. IFEX has also created resources aimed at making this type of information more readily available to CSOs, like our Global Advocacy Explainers, and most recently, we partner with Article 19, as Sylvia mentioned on Monday again, on a set of advo sheets, a series of advocacy sheets that explain the obligations states have and the commitments they have made regarding the safety of journalists under international human rights law, produced to support CSOs' advocacy efforts. It's also crucial to ensure that CSOs have the necessary funding, accreditation, and other enabling factors in order to bring cases to relevant national, regional, and international mechanisms. In countries or regions where national court systems are corrupt or unreliable, or for regions like MENA and the Asia Pacific, where relevant regional bodies either don't exist or don't review human rights cases, this is especially important and makes the issue of CSO accreditation at the UN pressing for civil society organizations operating in these contexts. There is real value in documenting and analyzing case law as a tool for civil society action. The constantly moving strategies, modalities, and responses noted in this report that can either perpetuate or mitigate violence against journalists means that flexible and innovative counter strategies from CSOs are all the more important. CSOs can also be key motivators to ensure governments and intergovernmental actors adapt to and keep up with these shifting trends. This was affirmed by many panelists in the session on Monday, but they also reiterated that to do this, they must have the necessary resources to prioritize, adapt, and sustain their work. It's not work that lends itself to quick successes. The cases in the report demonstrate that all too well. As the expression goes, it's a marathon, not a sprint, and IFEX members are in it for the long game. As a network, we need to be creative, find new points of pressure and influence, and reach out to others to build an even broader movement. No one can do this work alone. So thank you again for inviting me today and for the excellent work that you do within the Global Freedom of Expression program at Columbia University. I look forward to our continued discussion and, of course, to our ongoing allyship. Thank you.
Thank you very much, Rachel. I realized that because we all know each other, I didn't introduce you properly. Rachel is the IFEX Deputy Executive Director. Barbara Bukowska is the Senior Director for Law and Public Policy since 2009, in Article 19. Barbara, the floor is yours.
Oh, sorry, I didn't know I'm able to unmute myself. Hello, everyone. Thank you so much, Ramiro and Columbia Freedom of Expression Program for inviting me to this event. Especially since there is a connection between Columbia University program and Article 19, since it was originally led by our former executive director. So we are very keen to continue our collaboration. So for those who are not familiar with Article 19, it's International Freedom of Expression Organization that works globally on many issues related to freedom of expression and obviously also protection of journalists, protection from physical violence, but also other threats and other forms of harassment, abuse, and attacks, as also described in this report. And this work is done both through our policy work and from our international advocacy, as well as direct work of many of our regional offices, who some of them even work on some of the cases which are mentioned in the report. So what I'm gonna do in my short intervention is just to mention, probably in slightly more detail, some areas of our focus which have not been mentioned specifically so far, but also reflect on some findings of this report and some issues which were mentioned by Ramiro in his presentation, and maybe reflect on why we are in a situation where we are and what we can do to remedy it. And actually to answer the key question which Catalina told us at the beginning, what can we do jointly as a community and also as international organizations working on the protection of journalists and fight against impunity in this area. So just to kind of reflect on the broader issues, I can only sadly agree and reiterate the concerns which were raised by Catalina and which are raised in the paper, that the protection of journalists and the number of physical attacks against journalists and other media workers around the world have been increasing, and they are increasing sadly in all parts of the world, including in Europe. I saw on the platform of the Council of Europe before this event, when I was looking at it, that physical attacks against journalists rose, almost doubled from 2019 to 2021, and this was also the era of pandemic when some movements were limited, but physical attacks against journalists increased. And this is obviously also linked to impunity for killings and other forms of violence against journalists, which remains persistently of high concern worldwide. And this is the key obstacle for ensuring journalists' safety. And even in few cases where the attacks or killings would increase, the global impunity rate always remains high. And the research shows that in 9 out of 10 of journalists' killings still remain unsolved and unpunished. And then obviously, if the murder of journalists is unresolved or unpunished, there is only very little to deter the continuation of the threats of violence. And also, this, I don't know whether this is reflecting in the report, is that there is no correlation between increase of killings of journalists and increase of other crimes, right? So it's not that journalists would be killed in the countries where there is high homicide rate already, but quite opposite. The killings of journalists and impunity for those crimes, a very unique issue across the globe, which actually shows that there is intentionality in targeting of journalists. So, and also from our perspective, from the work of Article 19, we also see that these physical threats are compounded by threats in other areas of work of journalists or through other means, so that there is evidence of an increase of digital threats faced by journalists. They are on rise. That the threats through hacking, through interception of devices, or through targeted or mass surveillance. And on the top of that, we also see increase of so-called like legal attacks or legal and judicial harassment. So this is increase of various civil law cases or administrative law cases against journalists. And it's very typical that journalists who are attacked are also facing other threats through courts or through the surveillance. So, so these threats are often correlating and existing next to each other. So, for example, if there is a smear campaign against journalists, which is undermining media outlet reputation or individual journalist reputation or credibility, there will be also this particular journalist or media outlet will be also subject of digital surveillance. Or if journalist is attacked or even killed, like an example in Malta by Carmen Galicia, she was also subject of multiple legal suits. So the journalists always need to navigate this very complex situation of threats from all fronts. And that's why one of our key recommendations from Article 19 is that the protection of journalists needs to be seen holistically in the context of other attacks against media freedom, and also in the context of problematic legislation and media freedom overall in the country. And that was already covered by Rachel, so I will not go in depth about that. So now I want to focus a little bit more on the findings from the report and offer some reflections from Article 19, and also this might help to answer the question from Catalina, what we can do about this. So first of all, if we want to resolve the protection of journalists, we need to increase political will, because the lack of these cases or lack of investigations or lack of concrete action is always linked to the political will in the country. And that means about both politicians or leaders, political leaders need to speak unequivocally and systematically against violence and attacks against journalists, rather, and this is more often the case, smearing journalists or verbally attacking them, or even kind of showing support to threats against journalists in other level. And then the political will stems also to independence in the institutions which are tasked with investigation of journalists, and how these institutions are equipped, how independent they are, and how capable they actually are to investigate these crimes, especially, which is again, very often when the violence against journalists is linked with political corruption or organized crime and links to that, or other serious problems in the society. Then we need to look at what is preventing these cases proceeding on the level of law enforcement. And on the level of law enforcement, we obviously have two stages. One is police, prosecutors, and then the second part is the courts. So the research which Ramiro presented obviously looks at the courts. So I will start with that and his comments, and then we'll speak about law enforcement later. So one of the findings which you had there is that, like, in some areas, like, there were very few cases, and then we can talk about what leads to the lack of those cases beyond the lack of political will, but also that the courts do not rely on those international standards or best practices from elsewhere, and these standards do not trickle down to the national level in many regions and many countries, and the courts don't enforce them, they don't even know about them. So typically from our community, we are able to educate courts when we raise these standards in a litigation, right? In criminal cases, or this is majority of the cases, when we talk about violence against journalists, the investigation or the case is between the state and then the perpetrator. So unless the law enforcement agencies kind of push for these standards, or there is ability of civil society or even representatives of the victims or next to kin to directly intervene in the cases or have some sort of say, and unless we train the law enforcement and courts in this jurisprudence and the standards, which Columbia University does, we can't probably expect from them to do this by self-study, or unless there is some concentrated action from the state to educate them about the standard. And that again goes back to the political will and to the infrastructures there. So for this, I think it's very useful for the civil society to do third-party interventions, and the research like yours is absolutely crucial there, because then you can point out to the standards from elsewhere, to the positive examples, and if the courts are open to these interventions, you can educate them about the standards and eventually, like, push for the standard to trickle down to local level. And then you can also do this at the level of higher courts, constitutional courts, or national Supreme Courts, to then educate the lower courts. I think that also we need to invest more resources on training of the law enforcement, and also equipping them with more tools where they can rely on these standards. So this means the protocols, the procedural guidelines for investigation, and obviously this presupposes that they will be independent and they will be open to that. And then what is kind of collaboration there internationally, and how to educate the law enforcement on using the standards further, so they would know what does it mean for investigation to be prompt. What does it mean for the investigation to be effective? What does it mean to be independent, and so on? And we have standards on this from the courts and from the jurisprudence which you uncovered, but then we need to make it actionable on the local level. This is even more so on the area of these new threats which you mentioned. I think Ramiro mentioned, and this is also in the paper, that there are these so-called new threats or new forms of violence against journalists through digital means, online harassment and abuse, and all the surveillance. But now I just look at the online harassment and abuse, which often is kind of linked to physical violence, or can be at certain level escalated to physical violence. And it's very difficult for the law enforcement to understand what is the level of the risk, when it should be actioned by them, or when it should be action by the social media moderation standards, or even how to flag this. So I think that this is a kind of gap which we have on practical level to understand responsibilities on the digital sphere between the different actors, and how to delineate responsibility between them, and for them to understand also when the threat reaches certain level, when the law enforcement should act. Not to mention that they don't quite understand how to do this through anonymity of some of those perpetrators, or mutual legal assistance with other countries. They don't even try, or even don't know how to process those requests if the threat comes from unknown source or another country. So I think that if for the future research, maybe if you deepen the research there, you will see that many of those cases, or very few cases, where you have are kind of haphazard or kind of luck, when the prosecutor took an initiative and then the court decided it, but there is no concentrated action or systematic action how to handle those cases. So that's very important, and maybe when you are doing this manual or further guidelines for law enforcement, this is something which you can look at, and I'm sure that this will be appreciated on a local level. And then the third area where we don't, or which can contribute to the fact that there are not many of like hundreds of those cases, even if there are hundreds of cases of journalists being killed or prosecuted, is the capability of these victims to claim their rights. Or often in the cases of killings of journalists, they're next to kin or a broader community who can pursue this case. Even if these cases are criminal cases where you don't need to pay for legal fees to the court, it's still quite expensive to pursue those cases. So unless you are represented by civil society, it's very difficult to sustain pressure and advocacy campaign to push for these cases to continue. There is also a problem of legal representation and time as well, because if those cases go on for a number of years, sometimes even like 10 years from the start till it reaches the European court or Inter-American court, I mean, obviously people move on and so on, and unless you have institutional backing, it's extremely difficult to sustain litigation on this matter. And then also to certain level termination of the victims or next to kin, and sometimes it becomes a full-time job for someone who wants to fight for the justice for their relative or their husband or mother, as in case of Mrs. Galicia, her sons took it on. So there is this kind of broader infrastructure needed for these cases succeeded and even reaching the courts before you can talk about the positive jurisprudence on country or even regional level. And that's still just talking about this last leg of the problem when we talk about the prosecution and punishment for the crimes against journalists and for the violence, but then there is also this preceding leg of prevention and protection. And at that level, there is still a lot to be desired in the countries which have the high level of violence against journalists. But obviously, this is an issue before we even reach to the courts. And the focus of this paper is the courts. So I will stop there, but I will be very happy to answer further questions on this. Thank you.
Thank you very much, Barbara. I should say that audience members, the chat of the Zoom meeting is open. So if you want to submit questions, you can do it through the chat and we can read them. I had a couple of comments regarding your two great presentations. The first thing that I wanted to say is that, of course, when you look at the issue from the point of view of cases, when you see the issue of violence against journalists through cases, and then you hear from you guys that attacks have been increasing in the past, it creates this sort of cognitive dissonance, because in many of those cases, especially in the regions where international standards haven't yet really penetrated the local legal culture, you cannot help but conclude that those cases are in fact increasing because judges and as Barbara mentioned, police officers and security services are not doing enough, basically. So that's like a troubling conclusion, and also something that it seems to me must be worked on. The other thing that you mentioned, and I think it's important because I think it also comes from the cases, is when institutions, police institutions and judicial institutions are sort of weaponized in order to function as a form of harassment. We've seen that a lot of the cases that we've analyzed in Asia and MENA, but especially in Asia, I think, you can see these security institutions and national security, or the public prosecutor office. In India, for instance, there are a lot of cases in which journalists are subjected to bails, and the good judicial decisions are the one in which bail, for instance, is established and preliminary detention is stopped. But the reason those cases exist is because there is this sort of weaponization of prosecutor institutions, of police investigations, and of the judiciary itself to work as a form of harassment. And that, of course, is a huge problem. Now, something you mentioned has to do with the increase of the political will. And another thing that you also mentioned has to do with something Rachel said regarding the connection between civil society, advocacy, and case law. Regarding the latter part, I have a comment. It seems to me that there are bridges to build there. So the way I see it and the way that I imagine it, and I wonder whether you agree with this vision, is that case law can become a sort of a tool to fight violence against journalists in the hand of activists. So if activists know the case law, if activists know the international standards, they can use it as a tool. And under certain conditions, they can also use courts as an institutional mechanisms to sort of pressure public authorities from other departments of government, from the executive, to pressure the police and so on, in order to force them into action. I've seen that happening on other issues around the world. It seems to me it could happen here. Now, regarding the first point I mentioned, this is a question. How do you think we can increase political will? And have you seen cases in which sort of that was possible, in which the activism of civil society has managed to increase political will in a significant sense? This question is for whomever of you wants to answer. All right, yeah, sure.
Can I start? So I think I don't know whether I understood your first comment, because I think that this is often kind of alleged that as we look, for example, in the last 20 years, we have had this huge increase of positive and good standards from UN and from international human rights bodies or regional bodies on standards, but the cases and attacks against journalists are still increasing. So the standard didn't actually solve this problem, and that's absolutely true. And this is actually quite an important point for advocacy, because sometimes in advocacy, there's this obsession with within some civil society or some people that we just need a better standard to solve the protection. If we get a better standard, so we have an international convention on protection of journalists, everything will be solved. This is a fallacy, and this will not, which is actually documented by everything what we said. And that's why we actually have a good standards, and we need to rely on these standards to make them applicable in practice. And now, how can we push for the political will? So there are only few cases when public pressure pushed for impunity on the political level. So an example of this is actually Slovakia, when there was a journalist killed, Jan Kuciak, a couple of years ago, and then huge protests forced the government to resign and change the government. It was very, 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 very unique. And then the case is still not resolved. It's still pending through the cases, but it is possible. I mean, I would not say it's not possible. Also in Malta, there was like some huge outcry. I haven't seen these huge outcries in any other part. So it's very, very unique if this succeeds. But what succeeds is actually, and you said that the cases and case law is a tool. I think it's more than a tool. I mean, I think it's very important to get the justice for those who win, right? So for justice for the individual victims, but also as an inspiration and hope for the victims elsewhere. And this goes again to impunity, because these cases are increasing because there is an impunity, because we haven't resolved the impunity and the cases are still pending. So that's why if you win a case, even after 12 years in Colombia, this actually sends a very strong message to civil society in other countries, which are also having numerous of those cases, that it pays off if you stick to it, right? If you don't drop this case, if you really go through all of these stages and maintain the pressure. And then it also needs to be linked to other advocacy efforts. We cannot think that the individual cases will be sole solution to this problem. So one of the kind of like out of the box measures is something called individual sanctions. So there's this Magnitsky law, which we have been quite active on pushing for, which is individual responsibility for the violations on those cases. So for example, if some public official in Russia or in Mexico and so on was responsible for the killing of journalists, we can link a positive case or a case which shown that indeed there was this prosecution or a case was recognized, to push for other measures against officials or against the state. So for me, it's a part of a package rather than individual kind of tool we have as a part of the toolbox. And we need to see this in a complexity rather than in isolation. Because if we only focus on those cases and not on reform of the laws or working with the judiciary and so on, we will not succeed eventually on a broader problem and a broader level. We'll succeed in the case, hopefully, at some point, but not on a broader level of protection. So I don't know whether this answers your question, and maybe Rachel will have other view on that.
Thank you, Barbara. It does. Rachel, you want to weigh in?
Yeah, really, I was going to add to Barbara's comments, because the two cases that I can think of in the IFEX context that I mentioned even during my remarks are obviously Ginette Bedoya's case in Colombia, where I think there was a great deal of work by civil society organizations and Ginette herself to continue and to stay engaged in that case. But I think now the work is really to demonstrate, how that's important for broader cases of violence against female journalists. And I think Ginette herself has recognized how and has felt that this is something that's come forward. And we talk a lot about the fact that these, to Barbara's point about, they're not just cases in isolation, they are emblematic of other contexts, of other situations, and need to be used in order to bring, whether it's increased political will in the case of Ginette's case, or to bring, greater respect for media freedom and free expression in the country. And I think that's where the case in the Gambia was very interesting, because I think political will came in part from a change in government there. However, I think that the sustained efforts by civil society ensured that when that change came, they were able to take advantage of that political will and to really push for reparations that had been outstanding for years, and then continue efforts around other areas. For example, they last year finally went ahead with an access to information bill. And so again, bringing that broader context of these issues and the advocacy efforts is really key to that.
Thank you very much, Rachel. I wonder what you guys think about countries or regions in which the judiciary seems to be part of the problem more than the solution, because I think that generally that poses a challenge in terms of thinking about international standards in case law. I'm not sure. I'm thinking, for instance, in the few cases that we gather from Hong Kong. The judiciary and the decisions they issued seem to be part of the problem more than the solution. When journalists sought protection in front of police harassment, the judiciary seemed to have enabled that harassment. This is a very difficult question to pose, I know, but do you think there's anything that can be done in those circumstances?
To prevent judicial harassment?
To prevent I would say to deal with judicial or judicially enabled harassment. Mm-hmm. So which one, for instance, that happens when the judiciary is very deferential to police institutions or to security services, mm-hmm. when they're not only not using international standards in order to protect journalists, but on the contrary, they are enabling the use, for instance, of the security services to harass journalists when they authorize surveillance on them, when they imprison journalists under, crazy laws, which happens a lot as well. I wonder what can be done in those cases.
Yeah. So I think that this is a very important issue, but let's not just like fool ourselves. This will obviously depend on the country, right? Because we see judicial harassment or misuse of the law or instrumentalization of the courts happening across the board, right? So even in democratic countries or with the countries where you have independence of judiciary, this will happen, right? Let's say Italy, France, Spain, European countries, you have a lot of this cases against journalists being brought. We can argue whether you call them democracy or not, but like there are some sort of independent institution. Obviously, I would be very kind of naive if I thought that you can stop judicial harassment in countries like Myanmar, Russia, Philippines, and so on, when you don't have independence of judiciary, unless you have some like few exceptions among the judges who will be enlightened and not be misused for this, but probably it would not be, or it's not a focus of our advocacy in this area. But in countries where are either democratic or where they have some sort of like rule of law on a basic level, you can actually prevent this through reform of the laws, but also through actually reform of the laws, which on the face do not look like very human rights, but are on a procedural level, right? So let's say ability, or present it in a way which will be in terms of efficiency of judiciary, right? So if there would be in a country, hypothetically Serbia, there were like thousands of the cases brought against journalists or hundreds of cases brought against journalists, this is also a big burden on the state if they are eventually dismissed by the courts, or if they end up in European court and then the country has to pay a lot of damages to journalists. So for the procedural law, which on the face do not look very human rightsy, or are framed in the sort of efficiency of court administration to early dismiss those cases or prevent vexatious on non-meritorious cases, can be effective. But obviously you also need to have a legislation which complies with international standards and which doesn't allow for these cases to proceed to begin with. But this is how I would phrase or how I would structure the advocacy in this manner.
Thank you very much, Barbara.
Does it answer your question?
Yes, it does. And you highlighted a point that is very important, which I didn't mention when I discussed international standard, which is that laws that apply to journalists and to the media must abide by international standards in the first place, because when they do not, they usually encourage violence and different forms of violence. We do not have much time left, so I will just ask you if you would like to add anything to close our workshop. And before that, thank you very much for taking time to participate in it. I think I've learned a lot from it, and I'm sure our viewers have also.
Maybe just as to thank the Columbia University and to organizers for both of this project, but also for the database of the cases, analysis of the cases, and not only analysis and showing what these cases are about, but how they are important in the global context, because I can't even emphasize more what a great resource this database is and how often we rely on it. And it's like go-to a place whenever we are doing amicus brief, even on an issue which we haven't covered before. So please continue this work. And also, if people from countries that are not covered in the databases or lawyers or judges want to bring more, I think we need more. So we need many, many more people or experts who are having good cases or are litigating these cases to contribute to the database, or at least I would encourage everyone. And also you can promote your work and good cases and good results which you had. And for those who are not familiar with the database, I also encourage them to have a look. And also, as far as Article 19 is concerned, if we can be of assistance to your advocacy or to your work, please do get in touch. Thank you.
Thank you very much, Barbara.
Yeah, and I mean, I would just kind of add on to Barbara's point around and yours, I think earlier, Ramiro, I think more research or deepening the research into those regions where there were fewer cases or where there was that lack of connection to freedom of expression and to standards. I think would be very interesting to work with organizations in those regions, with cases in those regions, to see how you can further, get at some of the issues. I think what I raised around the regional systems lacking in some of those regions is obviously, a barrier to bringing that forward or to setting those precedents and those standards. But like Barbara said, I think identifying more cases, even if it's going back a bit further into those systems to see, to highlight where there have been positive examples and to be able to continue to bring that into, as Barbara said, those third-party interventions into amicus and other forms of civil society engagement. It would be great to have that. And yes, continued collaboration with Columbia University, as Barbara said, I think the database and the work that they're doing is incredible. And I think those are the kinds of partnerships and allyships that we need.
Thank you very much. Thank you both for participating. I always leave these workshops with the sense that there is so much to do, and I leave this particular workshop in a way thankful that the freedom of expression field has you both as leaders. So thank you. Thank our audience, those who are participating in the Zoom meeting, those who are watching on YouTube, and those who will be watching after this workshop is recorded. And please do engage with the database. Do send new cases that you think that should be included and aren't, because as much as the database grows, it becomes a more useful tool, as both Barbara and Rachel said. Thank you very much and have a good day.